All right, people. All right. You know, so we're still in the Integrity Commission. Integrity Commission segment is a whole week, is a whole month, is a whole year. And you know how them political analysts are going. So today we have Shereen, the Senator, Golin, this is a lawyer from England, and we have Clyde Williams, and them are going to break down the Integrity Commission decision to recommend the document to the Parliament instead of recommending it to the FID. And you know how it go already. Dan Jackson Miller, we know you are PNP. The lawyer, we know are PNP. The government member, Colin, we know so she is a Jamaica Labour Party. So listen to the panel. I'm not going to elaborate. I'm not going to blah blah what is going on. Listen to the panel and you will all understand what is going on. And then you can comment. Yes, you can comment your own feelings in at the comment section. Please remember to subscribe, like, share, click the bell so you always get a notification whenever I do go live or I do post a video. Listen to Dion Jackson Miller on the panel in regards to the Integrity Commission and the Oversight Committee. People them.
So did the Integrity Commission go wrong when it sent an incomplete investigation report to Parliament? That's been a big talk over the past week, and that's our topic for this edition of All Angles. Thank you so much for joining us. I'm Dion Jackson Miller. Joining me in studio, we have Shereen Golding Campbell, Government Senator and Attorney at Law. Matonda Makula is with us on Zoom from London, a Jamaican barrister, and also in studio, Attorney at Law and commentator Clyde Williams. Now, just before we go to them, yesterday, Parliament's Integrity Commission Oversight Committee met, and the report, as you can imagine, was one of the things we're discussing. So let's listen into this short excerpt, this in relation to a motion that opposition member Julian Robinson had to the committee to try to get the committee to endorse a recommendation from the Integrity Commission that the report should be sent to the Financial Investigations Division.
The letter is asking us to support the submission of this to FID, but I think it would be proper if the support was sought before it was submitted. It has already been submitted to FID, so why ask for support at this stage? Secondly, I don't believe it is within the remit of the Integrity Commission to submit such report to any other body except Parliament.
I've never heard of any instances where we have not accepted the recommendations of the Commission. And what Member Robinson and myself are seeking to do is to, in relation to that specific recommendation, and it is quite clear that it is an ongoing process, because when the FID does its investigation, I'm certain it will report back to the Integrity Commission, and after which we expect to get another report.
Okay, and therein lies a lot of the source of the controversy. I should say as well that we did invite a representative for the opposition to be with us. No members are available for tonight's program. All right, so I'm going to go around the room with a quick round robin. First of all, just yes or no. First of all, and then we can dig. Lawyers don't like yes or no. And then we can dig into it. So, did the Commission go wrong in sending the reports to Parliament in the way it did, Senator?
Yes.
Okay, Clyde Williams.
We wanted a complete report, not an incomplete one.
That's a yes?
It's qualified.
Okay.
It's qualified.
Okay, Matonda Makulo?
I think not. My answer is no.
Okay,
because it has provided users.
All right, well, let's dig into those then. Senator Golding Campbell, why yes?
Yes, because they have sent a report to Parliament, meaning an investigation has been conducted, a report has been completed, and a report has been tabled. That signals the end of an investigation. That's what the Act tells us. The report does not indicate at any point in the report that this is an interim report, which they would have the ability to submit to Parliament under Section 36. What we have is the end of an investigation and a report detailing the findings and recommendations coming out of that investigation. To ask the Parliament, there are two things. To ask the Parliament, one, to support their referring a completed report, a report on a completed investigation to another body, is inappropriate for two reasons. Parliament has no such authority. The Parliament can't go around referring people for investigation. That is not within any of the powers of any of the 63 parliamentarians. And secondly, having landed the report, tabled the report in Parliament, the only thing that the Director of Investigations or the Integrity Commission can do is refer it to their Director of Corruption Prosecution for a ruling as to whether or not the declarant is to be prosecuted. There is no further action to take on it.
Okay, Clyde?
The Integrity Commission has a certain amount of discretion to work and cooperate with other bodies, public bodies and otherwise. Though they haven't called it an interim report, that's how I've read it. Because I've read it that way because of what the chairman has also said in his letter when he said no question of certification will arise until FID is completed its work. I don't know the nature of the memorandum of understanding between FID and the Integrity Commission. But when I saw it, I recognized that they had not acted on some of the big issues, the tax compliance issues with the companies, the questions of whether the amount of monies in bank account of companies, whether the investigator saw any capacity to earn such monies. Those are things I understand him to be saying outside of his scope of time and also resources. Hence the reference to the referral to recommendation to the Commission to send it on to FID. So it is in that context that I read the thing as an incomplete, inconclusive report. I find that unfortunate because all of us in the society waiting for, and as Shireen said, you expect when investigations come that when you send the report it will be complete. But when I read it I realized it is incomplete because more than 3/4 of the report, no ruling has been made on about 3/4. The compliance issues with the tax, the question of the earning capacity of the companies in relation to the monies they have in their account, the question of whether or not the Prime Minister used monies in a charity to buy some bonds in his name, partially funding and so forth and so on, the question of the conflict of interest with his business partner being chairman of these. So those things are the substantive things in the report and they were all inconclusive. So I just concluded it was incomplete and I was dissatisfied. But I don't think it is beyond the Integrity Commission under the law to send the report to FID. Section 7 says a whole range of persons, competent authorities. FID is one of the competent authorities, the DPP, and MOCA and a couple others. That if those entities are investigating and request, then they can send all information they have to them. And again, the memorandum of understanding. So that's why I have qualified my thing. Disappointed, recognizing that it is not complete when you look at the substance of it. So I saw it as interim, though it doesn't say interim. And the chairman saying, I can't certify until, I can't come to a decision yet on certification until I get the FID work. That's not yet complete.
Couple things there, but Matondo, why are you saying no issue? No, you're on mute. I tell you what, thank you so much for staying with us. We're talking about the Integrity Commission's report on the Prime Minister's statutory declarations, not the content of it right now, but did the Commission blunder in how it dealt with the matter, in how and when it sent the report to Parliament. Just before I go back to my guests, let's go back to yesterday's sitting of the Integrity Commission Oversight Committee for another excerpt.
I am appalled that the Integrity Commission can present a report which is quite clear is, in their own indication, is incomplete, and therefore is asking for further investigation by the FID and the TAG, and now asking Parliament to support that recommendation, which is the substance of this motion. What is this report? Is this an interim report, or is this a final report? And I say, Mr. Chairman, what is before us? A submission to Parliament. It came clearly as a final report.
After examination of the report, thorough examination, it is laden with statements that are clearly prejudicial, more than they are probative, statements that have had no bearing on the findings, or ought not to have had any bearings on the findings, but that have been particularly included for a reason. I wonder, Chairman, if we ought not to be calling the IC before us to discuss the matter, to really investigate and determine, is this a matter of malicious prosecution, where clearly you see the inclusion of things intended to harm the declarant rather than to seek justice. These are matters that we have to explore, because it is highly inappropriate, in my view, for an investigation to be completed and for there to now be an effort to redetermine the matter. It's either that the IC is turning against itself, or that you have a situation here that is exposing itself as being a matter of corruption.
And just to remind Mr. Chuck that he, with our full support, almost at every committee meeting for the last few months, has been urging the Commission to update this committee on the issue of the so-called illicit enrichment investigation. And I think, Mr. Chuck, rather than to be critical, we must see this as a response to the urgings. And it is clear that this is an interim position, because it is subject, allow me to finish the point. It is subject to further investigations. And all that is being asked of in this resolution is for that work to be continued.
All right, so two things. First of all, the integrity commissioners, the commissioners of the Integrity Commission, have been told, have agreed to appear before the next sitting of the Integrity Commission Oversight Committee. That's going to be, I believe it's October 4. And the other issue in relation to viewers must be saying, so then can't even agree if it's a final report or an interim report. I suspect that's one of the first questions the commissioners will be asked to answer. Matanda Makula, let me bring you in. You were saying you have no problem with how the commission went about this. Tell us why.
Well, firstly, we have to accept that the commission has been given a broad discretionary power to conduct its investigation. The methodology that it uses is up to the commission. If someone prefers a different methodology, then they need to do more than scream, give me a different methodology. They need to demonstrate that the methodology used resulted in unfairness, or was irrational or unreasonable. And I haven't seen anyone advance any credible evidence to say that the process was unfair. Sending it to Parliament at this stage, and I agree with Clyde, that whether or not you call it an interim report, clearly it is for now an inconclusive document. So I don't see anything wrong procedurally in the way that it has gone about it, because I have not seen anyone point to any unfairness to Mr. Holness? Where is the unfairness? Because
let me paraphrase Deloitte Shock. I was interviewing him earlier. He also spoke, as you heard, in the committee, and he is saying there are a lot of statements in the report which aren't proven, no conclusions, all of which, I'm paraphrasing, have left this cloud over Mr. Holness's head and all of us in this state of lack of resolution.
That's not unfairness. He's complaining that at this stage, that it has left a cloud over Mr. Holness's head. That's not unfairness. How is that unfairness? That's not substantive nor procedural. The law doesn't recognize that. At this stage, the other bodies will be conducting investigations. I tell you what would have been unfair to the Prime Minister if there would have been a declaration and at the same time the Commission is asking the FID to get involved or the TAJ to get involved. Mr. Holness would have been in his right. It would have been correct to run off to the court.
I'm not following that point. Say that again for me. I'm not following that.
I'm saying if it is that there would have been a certification at this stage, and whilst there's a certification, you still have the IC telling the FID or recommended to the FID to get involved, then that would be an irrational position to be in. So I don't understand how the IC could have certified Mr. Holness's declaration whilst at the same time highlighting some concerns that it has and saying, well, investigate and look at these concerns, but we're going to certify his declaration. Those positions would be an irrational position to take. So that is why I'm satisfied with the approach, because it has decided we want to take this particular approach to investigating it, and that's what it did. No one can show me that it's an irrational or unfair approach. No one can show me.
Go ahead, sure.
I don't agree that this concept that the Integrity Commission has broad discretionary powers is only partly true. Because those...
Hold on, let her finish, please.
Those broad discretionary powers are constrained by the statutory provisions. It's not at large. And the Integrity Commission Act outlines how they engage what we're calling here further investigation. That has to happen in the course of them performing their function, the investigative function in this regard. And the Act sets out at Section 7 the authority that they have to contact a competent authority, and there are a number of them they list. Financial Investigation Division is one of them, and they can collaborate with them, share information with them in furtherance of their investigation. But they don't get to say, to complete their investigation, produce a report, and this argument about interim and final report, I don't buy this nonsense about interim report. This is a report. It has a title, investigation report. It has a content page that says says recommendations, law, evidence and discussion of findings, conclusions and recommendations. That's not an interim report. The difficulty we're having is that in the substance of this report, what are being called conclusions in many instances is conjecture. I'm not saying that there are not some areas where they're saying, boy, we need further information. There is that.
Flag two of them. Let's flag
two of them. Let's go to the conflict of interest one. Yes. Issue.
Your position is that it's a conjecture rather than a conclusion that he has drawn from his investigation.
Yeah. So the conflict of interest one, he makes certain statements. Perhaps I should go to the findings on it.
That's the director of
investigation. And he says, he gives us a whole thing about how he determines conflict of interest. And then he says, the similarity in the functions of HAJ and UDC and the relationship between Holness and Brown pose, and I quote, significant conflict of interest concerns. Remember, Mr. Brown is the chairman of HAJ and UDC, appointed by the Prime Minister. Both of those agencies fall under the Prime Minister. He continues, if this potential, so the significant conflict of interest concerns, but this is if this potential conflict of interest is not managed appropriately, it may be deleterious to the public interest. He goes further. Notwithstanding the foregoing, no direct evidence was presented to suggest that there has been any impropriety occasioned by the referenced potential conflict of interest. Well, there's no indirect evidence either.
Except, though, that what is being flagged there is a good governance issue. The director is pointing clearly to the fact that you have somebody who is a business partner of the Prime Minister appointed in positions which are under the Prime Minister's political portfolio, and he's saying that raises conflict of interest concerns. He also then in his recommendation says that the Parliament needs to look at how to manage these issues. So you are saying because he didn't say, boy, we see them do this wrong or we see them do that wrong, that he shouldn't raise it as an issue?
No, I'm not saying that. I'm saying the manner in which he has raised it, using the words he has used, has made it appear as if there is some wrongdoing here.
There's
But that's not
you
fair.
read that
But
suggests that.
Hang on, Matondo.
Okay,
Hang on.
Clyde,
Let me just say this before Clyde comes in. The raising of the interest, the issue of conflict of interest. Conflict of interest is something that is already incorporated in public body governance management. And there is a way of dealing with conflict of interest if it so happens that a transaction arises between the parties that calls that conflict of interest out of the sky onto the table. There is a whole process for that. So to red flag a potential conflict of interest when you're not saying that there is some suspicious transaction here is creating an issue in the report where none exists.
No, that's not fair.
We're nearly at the break, but I'm going to let Clyde start. We might have to come back after the break.
He says clearly he doesn't see any evidence that the conflict of interest has given rise to any malfeasance, any wrongdoing.
So why didn't he say indirect evidence?
No. Please, he said it very clearly. He didn't see any evidence of that. What he's saying, the conflict still exists. As to whether or not the conflict has been deleterious to the public purse or some other thing, that is for the Parliament Ethics Committee to look at the appropriateness and to have some rules as to how we deal with these situations.
I disagree with you.
No, but there is a conflict because he's a business partner of the Prime Minister who has been appointed by the Prime Minister to chair two significant entities within the portfolio of the Prime Minister, and at the same time he's the Prime Minister's business partner privately. That's where the conflict lies.
All right, we're going to take the break. Okay, we're back with you on all angles. I have to tell you, I wish you could be with us during the break because the discussion heats up. I'm going to go back to the Integrity Commission Oversight Committee though, because there was a part where I was watching the committee hearing and I started to feel kind of Twilight Zone-ish. Because this big argument that, and the argument then erupted over whether or not the report was dealing with illicit enrichment. And I was going, what do you mean? Take a look.
Member Paul will just draw some attention to what the state that Member Chuck has been saying for some time and asking about some report on the supposed illicit 6. And you said this is something, you refer to this as part of that? Is there anywhere in this report, anywhere at all, state that this report deals with anything named illicit? Anything illicit? I've gone through this report and I haven't seen anywhere in it that make mention to illicit. And you use the word illicit just now.
To be clear, Mr. Chairman, I was referring to firstly the preoccupation, I would say, of Mr. Chuck over the last few weeks into months. Because, in paraphrasing him, this announcement that there were investigations in relation to illicit enrichment that was in the report of the previous year, and that he wanted to get something final and definitive in relation to the persons who are so accused, and urged the Integrity Commission to come forward as speedily as possible to clear that cloud. And it is my belief, and substantiated by the letter and the interviews that the Prime Minister was subject to, which were revealed quite clearly that this was an issue of unlawful enrichment.
I think we all are aware of motives and intentions, and we must verbalize exactly what we think and what we want to be conveyed. Don't leave members to assume. And I think the member was quite correct the way you juxtapose the thoughts a while ago that this particular report was one of the illicit 6.
And I'm just going to read the headline. Submitted by the Integrity Commission under Section 36(3) of the Integrity Commission Act in the matter of an investigation report of an investigation conducted into the statutory declarations submitted by the Most Honorable Mr. Andrew Holness, Prime Minister, for the years 2019 to 2022, in respect of concerns that he owns assets disproportionate to his lawful earnings and that he made false statements in his statutory declarations by way of omissions contrary to law. That's the wording from the Integrity Commission.
All right, so I would just say for completion that the phrase illicit enrichment appears 42 times in the report. So let's go back though to the issue of conflict of interest. Matondo was trying to come in disagreeing, I believe, with what Shireen was saying.
Well, I don't agree with what Ms. Golding is saying, because if my friend is the Prime Minister and he puts me to chair a board, and that board falls within his ministry, every single right-thinking Jamaican will say, that no look good. That's what we call, lawyers would call, there's an appearance of bias there. That's the foundation of conflict. So I'm not understanding how it is that the DI is being criticized for pointing out a very, very basic thing that should have occurred to the Prime Minister, like, yeah, I can't do that.
Is it that he can't do it or shouldn't do it, or that there should be...
Sorry, shouldn't.
Or that there should be guidelines?
Yes, because remember, conflict of interest is not a crime, it's a question of morality and ethics in governance. That's what it really focuses on.
And what governance issues.
That's correct. And what it also focuses on is to head off and to prevent any possible corruption. Because if you are chairing, I'm not speaking about the Prime Minister, just conceptually now, a minister appoints his friend or his business associate to a board that falls in his portfolio, but the business that they do also are part of what the ministry does. So the ministry, let us say the ministry is involved in building houses and so forth and so forth, and you're engaged with your business partner in building houses or supplying those kinds of things. Those things could cause decisions to be made in the board level to support the business that they are engaged in. And so there's no evidence of any wrongdoing, and which is important. But what he's saying is that there is a question of conflict, and the Parliament must sort out the rules governing how we will deal with these things. And that's a fair thing for him to ask.
Your original question is, what are some of the areas in this report that I think call into question the timing and tabling of this report, okay? This issue of conflict of interest, and I don't want for us to take over the conversation with that. This issue of conflict of interest, having a conflict of interest is not necessarily a bar to engaging a transaction. There is a process for dealing with a conflict of interest. When you sit on a board of a public company and you have a conflict of interest, there you have a duty to declare. you have a duty to declare, and the board determines whether or not it is inappropriate for you to sit and take part in the discussion or not. More often than not, you recuse yourself, you step outside of the room, you do not attend the meetings that deal with that issue, and the issue is dealt with. You come back in and you deal with other issues outside of that. So to suggest, to red flag this in the way it has been red flagged, I think has blown it out of proportion, and almost, in my view, is adding one more thing to this report that I can throw in there to color how the Prime Minister is perceived. Because at the end of the day...
You're suggesting motive now.
I am questioning motive. I am questioning motive because the issue of this report being a report of an incompleted investigation is what we are talking about. The Director of Investigations at all times had the power and the authority to do what he came to, what he was asking the Parliament through the Integrity Commission Oversight Committee to do on Tuesday. This question of can you, Oversight Committee, support us Integrity Commission to go and refer this document to the FID and the TAJ? And the fallacy of all of it is that he didn't wait for the committee to meet to decide whether they were going to support it or not. The Integrity Commission, prior to this parliamentary meeting, referred the report already to the FID. So what you're asking Parliament to do?
Perhaps to give moral support. To say
really?
But he said that.
We support.
Yes.
Really?
To say we support ventilating this.
We're making a mockery of the procedures contained in the Integrity Commission Act.
I think that's extreme.
You calling me extreme?
No, I'm saying the position that you just hold of making it a mockery is an extreme position. The chairman was very clear in his letter. He says that he's asking you, the Parliament, to support this because he has the authority.
Not to give the permission.
He has the authority in law to give them this material. He's only saying Parliament support what we are doing. I want to come back to the conflict of interest point because this is what he says ultimately on this thing. I know, but I want to be fair to the gent. The DI recommends that a copy of this report be referred to the Ethics Committee of Parliament to examine and determine the appropriateness of a minister directly or indirectly appointing a business associate or other personal connections to a public board which falls under their portfolio. The committee should also consider whether there are sufficient safeguards in place to comprehensively deal with any conflict of interest situation which may arise as a result of personal and so forth and so on.
Really?
Hang on. So all I'm saying is that you're asking that the DI shouldn't have flagged that the Prime Minister appoint his business associate to chair two of the largest institutions within his ministry. He shouldn't have flagged it as a conflict. He ought to flag it as a conflict. And what he's saying is that further, please, further, what he's saying is that Parliament should develop some rules around this.
Matonda trying to come in. Go ahead, Matonda. You're muted.
I don't disagree with anything that Clyde has just said. I'm surprised that Ms. Golding is still maintaining this position.
And I will continue to maintain the position because we had no difficulty. Nobody referred Prime Minister P.J. Patterson to an ethics committee when Vin Lawrence was executive chairman of the UDC. It is the exact same example that you... No. Not because I've made a comparison means you dismiss me. It is the exact same example.
Hold on 1 second, please. Let me just let her finish the point. Go ahead, please.
Sorry.
When Mr. Lawrence was executive chairman of the UDC, which sat under the Prime Minister, nobody thought that was a conflict of interest. And he was executive chairman and served credibly or not. I don't know. I don't remember his active tenure. But he served. Now we're talking about a situation where somebody is chairman of HAJ and the UDC. And we're saying that just the fact of that is a conflict.
No. The relationship with the Prime Minister.
Let me
finish. The business relationship.
Clyde, let me finish as you asked me to let you finish. The fact of But it must be the relationship. The fact of the appointment because of the relationship is alone a conflict of interest. It is a potential conflict of interest. It is not an actual conflict of interest. When an actual conflict of interest arises, there is a protocol that Mr. Brown will have to observe. And if he doesn't, remember, he does not sit in that boardroom by himself. He sits in that boardroom. I think in the case of UDC, it must be about 100 of them on the board. But it's quite a big board. I don't know what the situation is with HAG. But there are a number of board members in that room who will have to take a decision, and he has to recuse himself. In fact, he has a duty.
All right, hold on.
To call it.
One at the break. You have 15 seconds to say why you disagree with
No, I've said what I have to say.
No, we didn't hear you though.
No, in terms of the conflict.
The analogy that he's making with PJ.
First, there was no commission at the time. That's the first thing. Secondly, even if people didn't say it was wrong then, and it don't make it right that Golin is doing that the Prime Minister is doing it. No, it was wrong then under PJ. Many people said it was a conflict, but they couldn't do anything about it. Many people said it was a conflict, but they couldn't do anything. It was wrong then, and it is wrong today.
All right, let's take the break and we come back. Much for staying with us. All right, so let me kind of bring the discussion back to the issue of the Integrity Commission having submitted this report on the Prime Minister's declarations to Parliament, because the thing is, what happens and where are we now? When you look through the Integrity Commission Act, right, it speaks repeatedly of when the members of the commission or the various directors are satisfied that something has been done. So it says, for instance, when the Director of Information and Complaints is satisfied that a statutory declaration has been duly completed, he's supposed to tell the commission then confirms that in writing. Where the director believes that an investigation is necessary, he must send the matter to the commission. The commission can also refer any matter to the Director of Investigations. And it also says when the Director of Investigation has completed an investigation and is satisfied that there are insufficient grounds, he should end the investigation. Or when satisfied there are reasonable grounds for suspecting a breach or an act of corruption, then it's supposed to be referred to the Director of Corruption Prosecution or the Parliament. But what happens if, as we're seeing in this report, the commissioners are saying, we're not satisfied. The director is saying, clearly, we're not satisfied one way or the other. Matanda, let me start out with you. So where does that leave us?
Well, it leaves us in a slight limbo, I accept. Yes. But it does leave us in limbo, I accept. However, it is not a limbo that is without a cure. I anticipate that the IC will return to this issue and see if they can sign off once the other competent authorities have looked at the issue. Let us not forget that the IC doesn't have the powers or the skills to look at tax issues. The IC doesn't have the powers or the skills to look at issues to do with financial crimes. And I don't think any sensible commission would sign off on a declaration when those two issues are standing unresolved. So where do we go from here? Have the FID look at it, have the TAG look at it, and then allow the IC to come back to it. There's nothing wrong with that.
Yeah. It would have been a lot tidier if they had just completed everything. The corporation, the TAJ people would come with their numbers, they would look at it, they would cross-reference, the FID would look at whether there are any financial improprieties and so on, and then submit that. It would have been a lot tidier. We wouldn't be here haggling over whether it's interim or otherwise. So I accept it's untidy because we have been waiting. It's untidy and it is in limbo situation. But because the investigator also has another option. He could say there's no basis for us to have any investigation. I don't see any evidence of any wrongdoing on the face of it. So we need to publicly exonerate this person. Make all of Jamaica know that there's nothing in this investigation that shows any wrongdoing. He has that option as well. My own view is that he should have taken one of the options you outlined earlier. Either we're going to recommend prosecution so it goes up to corruption prosecutor to decide, or we're going to exonerate because there's nothing in it, or we're going to stop it because it leading to nothing. That they have had an inconclusive approach. I would say it's untidy and it doesn't make for good governance, nor does it make for people having a lot of confidence in the Integrity Commission and how it's carrying out its affairs. Not that they're doing anything wrong necessarily. My own view is that this is a little untidy, and to have an interim report, and I'm saying interim because it's clearly inconclusive on the substantive issues, to have an interim report and then have FID finish their thing, come back to them, then what?
Shireen, take off our glasses. So.
Yeah, because I needed to see him properly and hear him properly, because let me just be very clear.
Back to you after
this is not an interim report. It cannot be an interim report, because on the provision of Section 54, the Director of Investigation has completed an investigation, sent it to the commissioners, and the commissioners have tabled it. He could have sent it to the DCP. He didn't. He could have gotten a ruling on wherever he was, and he did not do that. He has tabled a report, and he has tabled the report in circumstances where what he's asking to be done should have been done during the course of the investigation. And why do I say that, Dion? Because now you have tabled a report with all kinds of details. There are even the names of some of the witnesses in the report, even though they seem to have attempted to redact it. There are lots of pages where you see names of witnesses, where witnesses can be identified. The name isn't there, but their position and the bank they're at is there. You've put that into the public domain, and now you're going to ask another body to go and do work that you could have asked them to do. So I don't agree when Mutunda says they don't have the powers or the skills. They may not have the skills, but they most certainly have the powers under Section 7 to call up Mr. FID, call up Mr. TAJ and say, look here, I am doing an investigation on the Prime Minister. I have reached a point that I cannot continue. I need the skill set in your department. I am sending to you this information under cover of confidentiality and under the strictures of Section 53 of the Integrity Commission Act. Do your work and let me know what you find.
Just before the two of them comment, let me quote Lord Diplock to you though. Was it Lord Diplock? It's not the substance, it's the form. So when you look at the report, what you're saying, it has conclusions, it has recommendations and so on, but when you read the content, it's clear that it's not final.
I don't agree with you.
Yes. Okay.
I don't agree with you.
All right. Matondo?
But what Ms. Golding is advancing is a preferred approach. And I keep telling her...
It's a statutory approach.
No, it's a preferred approach. And you keep trying to circumscribe the wide discretionary powers that has been granted to the IC to suit your own agenda. And I'm saying to you,
let's not do the accusations and the motives.
When I say agenda,
but he can do that. But let him tell me what these wide discretionary powers are.
What do you mean?
Tell me what the wide discretionary powers are.
It has been granted a discretion to conduct investigation.
Under section what?
Hold on. On the Section 7, it tells you clearly that it is conducting, it can conduct the investigation. But let us, I don't think you must be the first person who wants to question that. What I'm saying to you is this. It has the power to conduct the investigation how it chooses to do so. It could have contacted the FID, but I'd say we want some assistance here. It chose not to do so. It chose to do it at the end. It doesn't make the process unfair. It might appear untidy to you, but it doesn't make it unfair. And that's the point that
I haven't used the word untidy. I am using the word contrary to the Integrity Commission Act. Under Section 7, when the Act gives an opportunity to collaborate and coordinate with another body in furtherance of the investigation, the Act is very clear in the performance of its functions while it is engaging an investigation. Under Section 54, when that report is completed and sent to the commissioners, it is on completion. Section 54 repeats the word completion 2 times. on completion of an investigation.
We have about 4 minutes left, so it's going to be, we're coming to concluding comments.
We'll that quickly. The entire report, you can see that it's an interim. And again, I come back to what lawyers say. It's not what you call it, it's what the substance of it. So you may not want to call it interim, but for instance, he says at the end of his recommendations, the DI's powers and limited resources and exigencies relative to remit and time do not allow him to sufficiently ventilate this issue. And that's the issue dealing with the FID and TAJ, the companies and so on.
What page is that?
That's at 6.23. That's page 155 of 171. So he says that very clearly at the end of his recommendations. He's saying, listen, I don't have all these resources, and that's why I'm asking for these various persons, TAJ, FID, to do. I agree with you, and I've said it, and we have accepted it. It's a little untidy.
But why table?
Yes, no, but I'm saying to you, you have to go and ask why they did that. All I'm simply saying is that it's a little untidy, but he does say that I do not have these resources to complete.
I have one question as well. What would have happened if the Integrity Commission had not tabled the report? If this investigation had gone on for another 2 years, another 3 years, with the parliamentarians howling for some resolution, some information, the public saying what is going on, nobody knows what is going on. Would that even have been tenable?
No.
Maybe not.
They would burn
Maybe
the house
not.
down.
But the problem with that, Dion, is that after almost 3 years, this collaboration or referral, if you want to call it that, to the FID could have been engaged. And that is the problem I am having. You take all this time to come to a point to tell me you now want to do what you should have done all along.
Well,
if that is what the skill set is and the kind of deep investigation that you wanted to do. But to come to the Jamaican people and say, I have expended these resources, hired an international forensic examiner, hired him for 6 months. He has gone through how much of these accounts and deposits and withdrawals and whatever. I don't have anything. So now I want to go to FID. Why you didn't go to FID before you went to the International Forensic Examiner?
A minute for final reports and just the final comments from the other two. And just to say that the Integrity Commission did respond to me in a statement and said they did engage with the FID at the beginning of the investigation. They decided not to go further with them until the end. I guess they would have to explain why. Final quick comment.
I'm a man for substance and content. And when I look at the substance and content and the questions raised here, I am not going to cause my ants with the procedures that were employed and its untidiness and we're fighting over whether it's interim or to cause me to back away from. I want some answers. I want to know if the Prime Minister's companies did try to undermine the tax authority and the tax laws. I want to know whether or not the Prime Minister had used resources that were for charity to help to finance some purchases for himself. I want to get some answers to those questions.
Matonda, you get the final word, final minute.
And I could add to Clyde's position, when there are 20 cash deposits in 2020 of $4.5 million, I think we should be more concerned with that than being hung up about...
Sorry, I didn't hear you clearly. Repeat that for me.
I'm saying when there are 20 cash deposits into an account belonging to my Prime Minister over a 3-month period, I want to know why it is that had to be done via cash and not the ordinary electronic system. I'm more concerned with that, and the people of Jamaica must be concerned with that than whether or not the FID is going to look at it or the TAJ is going to look at it after the IC has looked at it. Perfectly normal. Be more concerned with the glaring issues that I say in any other democracy, we would have we would have had a new leader of our country if these issues were flagged.
Have to leave it.